One of the most critical pieces of your paper trail, your workarounds, your compliance program is to obtain powers of attorney from your executive officers and the members of your board of directors to enable you to timely make Section 16 filings with the SEC on their behalf. Today on Zippy Point. I'm Brock Romanek. I'm a big fan of use. A power of attorney, often referred to informally with its acronym POA, is a legal document, that legal mumbo jumbo giving one or more persons the power to act on behalf of another person. For this purpose, the agent is also referred to as the attorney in fact. That's a common term for who has the power to act for another person, but they don't need to be a lawyer to be an attorney in fact. And in fact, in this case, for this purpose of filing Section 16 reports, they often are not a lawyer. They're someone in the stock plan administration department or the corporate secretary's department of the company. They're going to have limited legal authority to act on behalf of the executive officer or director to file Forms 3, Forms 4s, Form 5s. And I'm going to refer to executive officers and directors collectively as insiders during this Vid-Guide because that's what they're often called. Without a written power of attorney, the insider has to sign their own Forms 3s, 4s, and 5, and particularly for Form 4, which is a 4 business day deadline, that's just unworkable, impossible to do. And without that written power of attorney, the person they would be signing on behalf of that insider would be violating the equal dignities rule, which is a legal doctrine requiring that the agent perform all acts that are authorized by the principal, by the insider who has authorized that person to sign on their behalf, but only if the agent's authority is set forth in writing. This equal dignities rule is akin to the statute of frauds, which states that a contract would be void unless it's reduced to writing. So here are 5 things you should know about powers of attorneys for Section 16 purposes. 1, get that power of attorney right away. You'll typically have the insiders execute their power of attorney even before they first become an insider, or will be on the first day that they are one, so that you can file their Section 16 reports for them right off the bat. The Form 3 is due 10 calendar days after they become an insider. And if they don't already have their own Edgar code, so they're not serving as a director for another public company, or they're an executive officer for a public company already, you're going to have to help them get their own Edgar codes. That requires filing a Form ID with the SEC, and there's a bit of a turnaround time and lots of possibility for technical snafus that take a bit of time to iron out. So if you need to file a Form ID, you want to get that done right away. You're going to have something notarized, the Form ID, and that could take time to get just something notarized. If you don't have a notary hanging around, or if you don't see that insider pretty quickly after they become an insider. So overall, this can be a time-consuming process and eats up the clock as you race towards that 10-day deadline for filing the Form 3. Now, the SEC doesn't require that a power of attorney be witnessed. There's no magic language for it. What you say in the power of attorney is up to you. Bear in mind, you might have state law to consider. And if you look at the sample powers of attorneys out there, the ones that are filed with the SEC, they definitely are not all identical. They can be similar, but I'm actually surprised by how much variance I see. And I don't want to get into the weeds about state laws that might require powers of attorneys to be notarized or contain specific language. And maybe that state law would trump the SEC's own signature requirements for these Section 16 reports. Maybe not. Obviously, if you're aware of a state law that has some sort of archaic type of requirement, you might as well comply with it and be safe. 2, decide what forms it covers. So the power of attorney should specifically cover all Section 16 reports and state that in your power of attorney, all Section 16 reports, and I would actually including Form ID, Form 3, Form 4, Form 5. I would include the Form ID in this power of attorney since you likely will be filing the Form ID on behalf of that insider if they don't already have their Edgar codes. The power of attorney might also cover Form 144s if that's a service that people within your legal department and within your company provide on behalf of your insiders. And if it's a small company, perhaps you might even throw Schedule 13G or 13D in there if you might be filing on behalf of like a CEO who really is a founder who controls 5% or more of the company's stock. That's pretty rare, but sometimes it happens. 3, determine how many attorney in facts you have. So you want this power of attorney to run to at least 2 people in the company in case One or more of them is unavailable to sign a Form 4. Someone's on vacation, someone gets sick, someone quits. Some companies have 4 or more people named as attorney-in-fact. Time is short and you don't want the hassle of hassling an insider to sign a form because your compliance people happen to be on vacation or out of the office at the same time. 4, include magic substitution language. So you want the people who are named as attorney-in-fact in your power of attorney to be allowed to name any substitutes for when they leave the company, they're out on medical leave for an extended period. So you want this kind of language baked into your power of attorney, that there's full power of substitution and resubstitution, or that people holding the same title can act in the capacity as the agent. I see a lot of power of attorneys that actually don't have this language in it. I don't understand why not. It's important to have. 5, decide when to file the power of attorney. So the power of attorney needs to be filed with the SEC. It's filed as Exhibit 24 when it's filed with either the first filing, Section 16 report you make with the SEC, that would be a Form 3, or let's say you forget to do that, or for whatever reason you don't do that, you'll file the power of attorney as exhibit to the first Form 4 you file. And it's labeled as an Exhibit 24 because of Item 601 of Regulation SK, which requires that power of attorneys get labeled as Exhibit 24, as you see here in an excerpt from Item 601. So here's where it gets confusing. If an insider does need Edgar codes, you're likely going to file that Form ID on behalf of that insider so that you can handle any technical issues that may arise. If there's a bounce back saying it's not accepted for filing when you submit it through the electronic system that the SEC has, you want that email saying it didn't get accepted to come back to you so you know you need to fix it. You don't want that email going to a busy director, a busy executive officer who's not going to understand all this Section 16 stuff, all this Edgar stuff. So when you sign the Form ID on behalf of the insider, you need a power of attorney for that, and then the SEC requires that you file the power of attorney with the Form ID. Here's an excerpt from a page on the SEC's website that explains the whole Form ID process and explain how you need to include a power of attorney when you file a Form ID. Now, even if the power of attorney is submitted as part of the Form ID process, it still should also be filed as an exhibit to the Form 3 when you file that Form 3. The SEC staff takes the position that a power of attorney must be filed as an exhibit to a Section 16 report, even if it has already been filed as part of the Form ID process. So this makes sense because you need to get the power of attorney into the insider's filing stream, the SEC's reporting system. And then here you have an FAQ number 5 from the SEC's Section 16 electronic reporting frequently asked questions that notes that the power of attorney must be filed with a Form 3 or Form 4, and that the power of attorney must state its duration. That typically is described in the power of attorney as lasting as long as the insider is required to file Section 16 reports for being an insider for this company. So it's typically not expressed as a specific duration like 1 or 2 years. It's expressed as long as this person's an insider for this company. That language should be in your power of attorney too. So I see quite a few Form 3s filed without power of attorneys. My guess is those folks assume that a power of attorney with the Form ID covers their bases. I'm not sure why they're doing it like that. They may even have been told that it's okay to do it like that by the SEC's Edgar filer support staff. But personally, I would not rely on that part of the SEC, those staffers, to give you legal advice. They're customer service people. Actually, when Sears goes out of business, the customer service people that work for Sears get hired by the SEC. I'm just saying, they're not lawyers. And if you happen to forget to file your power of attorney as an exhibit to your Form 3, go ahead. That means then that your insider actually signed the Form 3 itself, not you, not someone else who's an agent. Then you're going to file that power of attorney now that because you've remembered it with your next filing, which would be the first Form 4 for that insider. Otherwise, that insider is going to need to sign all the forms each time they file, a nearly impossible task given the 4 business day deadline for Form 4s and the fact that they're not going to know all this Edgar stuff. Don't structure it that way. I don't know anyone that structures it that way. Let me talk for a minute about Edgar. It's very old. It's a little tricky. It can be quite fickle. So last I heard, when you have a power of attorney, you probably need to convert it to a text document and ensure that there are no quotation marks in it, and that when you name the document, it can't have any special characters, and it has to be all lowercase with no spaces. things might have changed. You'll see for one of the examples here, the power of attorney was filed as a graphic. So that might enable, so apparently that's feasible to do. But be aware that it might take you a few tries to get the power of attorney accepted by Edgar. So be prepared to be perhaps a little frustrated. So here's an example of a Form 3 with a power of attorney filed as Exhibit 24. And like I noted, this is the one with the graphic image. And then here's another example. This power of attorney looks like it's HTML. And then here's one that actually includes Form 144 as well as the Section 16 reports. And this text format actually looks like it might be ASCII, which I didn't think Edgar, I think Edgar only accepts ASCII with the exhibits these days and not in. Anyways, let me know what you think. This is a confusing area.